truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis, as we are once again together, you and I, to discuss Chad and Lori Daybell. Folks, did everybody have a good weekend? It's Monday, and old KJ is here to emphasize our two bits of good news from last week. Obviously, I went overboard when I did my Carol Burnett impression of Lori finding out that she is going to have to stand trial. She's competent. I hope y'all got a kick out of that. And the second bit of news was Judge Boyce also had an order saying that at this point he sees no reason that Chad and Lori cannot be tried together. Now, I consider that a Thanksgiving blessing, and I also believe that it is a Christmas gift to us all. We've been studying this case for over 2 years, and I appreciate all of y'all hanging tough with me, your comments, helping me go through this transition away from live stream. I just want to thank each and every one of the Rays on here for just being there, just hanging tough with me. I love each and every one of you, and I'm going to continue to get justice through understanding no matter how, why, when, whatever. We're going to do this together. I'm not backing down. You know me by now. I'm trying to keep a light on this case for the family, the victim's family members. And let's not forget that Jason is still in the hospital. Cresha came out yesterday with a live stream, giving us an update on his health. Let us continue to pray for him, pray for their whole entire family. And so with that said, of course, I guess I kind of went overboard with the news of Lori because she's been faking her ass off all this time, in my opinion. But I also just put on the community wall the second good news, and that was that Chad and Lori at this point are going to stay together, and they're going to be tried together in a joint trial. Now, just as Kay Woodcock talked about in their last interview, she said they're going to have to schedule a hearing for another hearing for another hearing. It must be very frustrating for the Woodcocks and for Cresha, her family, and all the other victims' family members. What we need to do is keep a light shed on this case as much as possible, continue to get justice through understanding, and I couldn't do it without all of you. You've hung tight with me over 2 years, y'all. We've been trying our very best to pick through this case, to be able to dissect it, to look down paths of discovery, to get the whole environmental view through application. So today I'm going to be going over the order of Judge Boyce. And the reason I'm going to be doing this is because, I've already shot a vid on John Pryor talking about this crap that he wants to pull with Lori and Alex in Arizona and all this and that. We kind of see where he wants to go with all that. But the bottom line is if we go through this order and we look at everything that John Pryor has discussed, his reasoning to want to sever this case, then we will also see where Judge Boyce and the state of Idaho stands on these issues. So I'm going to read through this order, and I'm going to stop here and there to kind of give my views, to kind of veer into the defense's strategy, and to also look and see how and when this might eventually be tried, okay? So this was the final order, and it was filed November the 17th of 2022. And this is from Judge Boyce, and I'm going to read through it. It's a lot of legalese. Many of y'all have read this. I put it on the community wall, but I also want to kind of break it down and put it on the record, really, because we've always went over the legal documents, okay? So here we go. Pending before the court is defendant Chad Guy Daybell's motion to sever from death notice co-defendant in order to enforce Mr. Daybell's constitutional rights, filed September the 27th of 2022. On October 6th of 2022, the state filed a response to the motion objecting any severance of this case from Fremont County case number CR 22-21-1624. On October 12th of 2022, the state filed an objection and memorandum in response to the defendant's second motion to sever. On November 10th of 2022, the parties appeared before the court to argue the motion, at which time the court took the matter under advisement. Having reviewed the record, the parties' arguments, and relevant legal authority, the court issues the following decision and order. And for those that did not watch, well, they didn't watch, it was an audio recording that was brought out by East Idaho News. You can find it on their website. You can find it on YouTube, where John Pryor gives his arguments and the state gives theirs, okay? But obviously, when it comes to these orders, sometimes, we think that they're not important, as long as we know what they're about, right? Oh, okay. KJ's just going to tell you that Chad and Lori are going to be tried together. Let's just forget about everything else. Let's not learn anything. Let's just say they're going to be tried together and leave it at that. See y'all later. Goodbye. No, it's not going to be that way. It's never been that way on this channel. And we're going to continue to move forward to know that there is factual and procedural background in every order that Judge Boyce issues. He always wants to make it clear what's went on up to the point that he has to deal with this motion once again and make his ruling. On May the 24th of 2021, a Fremont County grand jury returned an indictment naming Chad and Lori and Alex as co-conspirators in the commission of several crimes, including but not limited to multiple counts of first-degree murder and conspiracy to commit first-degree murder. Now, let's stop there for a minute. Remember, we discussed it about the different financial frauds. Lori is Social Security fraud. Chad's is insurance fraud. Now, it's very interesting, and I've never brought this out before, that Chad is not, he could have conspired with Lori in her Social Security fraud, but he wasn't charged with that. And Lori could have conspired in financial crimes with Chad on his insurance fraud, but she was not charged with that. So in a legal viewing and lens of that, Chad did his financial crime himself, and Lori did her financial crime herself. Now, we know, common sense says, that they were talking about all this shit. They were talking about it, but the state did not charge them with Lori with conspiracy to help Chad with insurance fraud, and did not charge Chad with conspiracy to help Lori with her Social Security fraud. So that's something that's not been brought out before. But nonetheless, they are financial crimes. They're different. But, the bottom line is the state is looking at the conspiracy to commit murder, first-degree murder, and conspiracy to multiple counts of first-degree murder and conspiracy to commit murder. Now, as we know, Lori was not charged with murdering Tammy Daybell. Chad was charged with murdering Tammy Daybell. And what's interesting about it is you don't see, in terms of first-degree murder, you don't see that Lori is charged with first-degree murder per se, although conspiracy to commit murder is the same thing as first-degree murder. What I'm trying to say is, in terms of the indictment, it seems to me that when they say conspirators known and unknown, they're also talking about Alex Cox. So even though Chad has been charged with Tammy's first-degree murder, he was there, he did what he did to her. In my view, he waited in the evening. He might have been poisoning her slowly. I don't know for sure about that. But at some point, he murdered her. Whether it was through poison, whether it was through suffocation, whatever it was. So Lori is not in that at all, and neither was Alex. On June 9th of 2021, Daybell was arraigned on the charges listed in the indictment. On August 5th of 2021, the state of Idaho filed a notice of intent to seek the death penalty on August 6th of 2021. This court ordered that both Daybell and alleged co-conspirator Noreen Vallow Daybell were to be tried together in a single trial, finding this joinder of the defendants was proper under Idaho Criminal Rule 8B. On September 7th of 2021, Daybell filed an Idaho Criminal Rule 14 motion for severance, contending that severance was required to afford Daybell a fair and impartial trial, and supplemented the motion with a memorandum filed February 9th of 2022. On February 24th of 2022, the state filed a response in the objection, arguing that Daybell failed to meet a burden to warrant severance. On March 18th of 2022, the court heard the parties in argument on Daybell's motion to sever. On March 21st of 2022, the court issued a memorandum decision denying defendant's motion for severance. And y'all remember, that was the first one they tried. On September 27th of 2022, Daybell filed a second motion to sever in a 30-page memorandum in support of the motion. The state filed a response to the motion on October 6th of 2022. Further, on October 12th of 2022, the state filed a 34-page memorandum opposing Daybell's motion to sever. On October 13th of 2022, when the hearing was originally scheduled, the parties agreed to continue the hearing to November 10th of 2022. In the interim, the court granted Daybell's motion to continue trial and vacated the January 9th, 2023 trial date. On November 10th of 2022, the parties appeared before the court for argument on the motion to sever, and the court took the matter under advisement. For the reasons first stated in March 21st of 2022, and as more fully explained herein, the court again denies Daybell's motion to sever his trial from defendant Vallow Daybell's trial. So that is the background. And again, John Pryor, remember I told y'all the last time I put it on the community wall that I was wrong. I really thought that they would have, if there was any chance at all, they would get a severance. Because this was before it was announced that Lori was competent again. And I did not know how long she was going to stay incompetent. And so I thought if they were going to have a chance, if John Pryor and old Chin there was going to have a chance to get the cases severed, I said that would be the time. And he, you could tell this time he was ready. He had, first he had just a memorandum. The first time he tried it. This time he tried several pages long, 30-something pages long. He had it all ready to go. And the state had to counter that. And the bottom line is that the judge, he's done everything on the level. It didn't seem too long ago that everybody was dogging out, bitching and complaining about Judge Boyce, but he has kept the course. And again, I will stress that I have all faith and confidence in Judge Boyce's decisions. Now, there's a standard of review that the judge has to make clear in his decision and in his order. And this goes with all the legal orders that Judge Boyce has given since we've been going over them for 2 years now. Well, less than 2 years, because before Judge Boyce was on there was Edens. But the bottom line is there is a standard of review. And the standard of review is I'm going to review this, and there's a standard that me as a judge, I've got to do. So he says, joinder of two or more defendants is proper if they are alleged to have participated in the same act or transaction or in the same series of acts or transactions constituting an offense or offenses. And this right here is Thune versus State. And this tells you why a case should be joined together. And in most areas of criminality, nothing seems more appropriate than what? Conspiracy to commit whatever crime. This would be the best time to try two defendants or more than two defendants. If Alex Cox was still alive, he would be sitting right along with them. Actions properly joined under Idaho Criminal Rule 8B may be severed under Idaho Criminal Rule 14 if it appears that a joint trial would be prejudicial, and that was State versus Gamble. And it goes into it. A criminal defendant bears the burden to show what? Prejudice in making a motion to sever under Idaho Criminal Rule 14. Now, John Pryor says, I want this severed under Criminal Rule 14. And so the judge is showing you in the order what it actually says. There has to be some form of prejudice. Not that Chad doesn't get any sex from Lori anymore and they're little hopping around in Hawaii and doing all the crazy shit they did is at a standstill now, and they're sitting in jail cells, and Chad doesn't want to have to deal with the repercussions of his shit, and Lori doesn't want to deal with Chad anymore. The bottom line, prejudice has to be more than just they don't want to be sitting at the table together. And by the way, as it goes down here further, it is going to look damning for both of them to sit at that table together. And people might say, well, that's a little prejudicial. It would be less prejudicial if Chad was there in his own trial or Lori was in her own trial. But having them both there, that just looks so bad. Well, they shouldn't have. They shouldn't have done none of this shit together. Then they wouldn't have to worry about it, right? Such motions are committed to the sound discretion of the trial court in terms of the Criminal Rule 14. In other words, Judge Boyce has latitude. This is his discretion. This isn't something that Judge Boyce is locked into, where he has to okay, Criminal Rule 14, it says I got to exactly do this. He has discretion, and Judge Boyce has ruled and ordered correctly. An appellate court, now this is Judge Boyce talking to you. He says, an appellate court, which is above him, will review a trial court's denial of a motion to sever pursuant to Idaho Criminal Rule 14 for an abuse of discretion, and that is State versus Fox. And the reason he puts this in here is hey, I'm ruling this way, and it is automatic. It's automatic that if I join something and I don't sever it, that an appellate court above me can review it. So Judge Boyce is basically saying, I know what I'm doing. I know exactly what I'm doing. And I'm telling you now that if I wasn't secure in doing it, then, you can see that someone above me is going to look it over and see whether I did a good job or not. He is confident, y'all. So this whole idea that this could be an appellate issue, the bottom line is he seems to think he's got his stuff down. So we go from the standard review to the analysis. The analysis that Judge Boyce is looking at when he makes this order and decision. As the outset, this court again articulates its previous finding that Fremont County case, this is Lori's case number and Chad's case number, are properly joined for purposes of trial because the indictment alleges that both Vallow Daybell and Chad Daybell, quote, participated in the same act or transaction or in the same series of acts or transactions constituting an offense or offenses, unquote. Further, trial courts are instructed to construe the criminal rules to secure simplicity in procedures, fairness in administration, and elimination of unjustifiable expense and delay. And that again is State versus Fox. So the judge is saying in the putting them together, if they've got all these offenses that they did together and everything, that the trial court is instructed to, Judge Boyce has to say, okay, this is what I've got to do. I've got to make sure that it's as simple as possible, that it's fair, and there shouldn't be any unjustifiable expense, and there shouldn't be any delay. And the reason that we've had such delay is because Lori's been faking her ass off, And Chad has been continuing his stuff all this time. 1 minute John Pryor says, we're ready to go. The next minute he wants a continuance. Further, trial courts are instructed, Idaho Criminal Rule 14 provides a backstop, okay? A backstop to prevent joining charges in a manner that may unfairly prejudice a defendant. So what Judge Boyce is saying is this Criminal Rule 14, it's a backstop. It's going to keep Chad and Lori from being unfairly put together. And, John Pryor can whine and complain all he wants. But don't you find it interesting that Archie hasn't filed anything to try to keep them separated or severed? Don't you find that interesting? In bringing a motion to sever under Rule 14, Daybell enumerates several sections of both the Idaho and federal constitutions as additional grounds to obtain severance. Specifically, Daybell argues 5 key reasons in justification of the request to sever his trial from Vallow Daybell's. So there's 5 reasons that John Pryor wants to list in here, and here they go. A heightened reliability required in capital cases. And y'all remember that video where I said if there was going to be a severance, the one thing that I was hanging my hat on is this is a death penalty case. And this might, and in the back of my mind, I'm thinking, Lori's still incompetent, and this is some serious shit, and this might be the reason the judge severs the cases. So that was one of them. Number 2, a joint trial materially prejudices Daybell. And this is what John Pryor accuses this whole joinder of being, that it's just prejudicial left and right. It's not right. It's unfair. So it's not only because it's a death penalty case, because there is materially just a bunch of prejudice in it. The third reason is precedent exists to sever cases subject to the death penalty. And as y'all recall, I told y'all there is precedent that sets up that they could be severed. If it was going to be severed, it isn't that it's never been done before. So John Pryor gives that reason. Then the fourth reason is judicial economy, which I don't know exactly where John Pryor is going with that. 2 trials seems to me as, double your costs there. The fact that one trial is already had a change of venue and Chad is supposed to go to Boise, would that mean that Lori would go to Boise? This whole process would start all over. John Pryor is not thinking clearly on that, but again, he lists it. And the final reason that John Pryor wanted this case severed was the Daybell's need for additional time to prepare for the defense. Now, at the bottom of the fourth page, it has the notes section. And Judge Boyce says, well, John Pryor, you asked for a continuance and I gave it to you. So that point number 5 is moot. If you're going to say that Chad Daybell needs additional time to prepare for a defense, John Pryor, I'm telling you, I've done given you another continuance. We shut down the January 2023 date for y'all, so it's a moot issue, so you can cross that one off your list. The state opposes severance, first noting that this motion recycles arguments previously denied by the court in the first motion to sever. The state also asserts, number 1, that the defendants in the companion cases were properly joined under Idaho Criminal Rule 8B, and number 2, that Idaho Criminal Rule 14 requires the movement, which is Chad Daybell, to establish what? Prejudice. John Pryor said in the page before, there's just so much prejudice here. And that Daybell has failed to meet his burden to show how he's prejudiced. In that, the defense merely advances. Now, hear me out. John Pryor merely says, and again, y'all can go listen to the audio on East Idaho News, some concluding that statements as to how Chad Daybell has or will be unfairly prejudicial by a joint trial. In other words, give it to us. Tell us why he is going to be prejudiced. John Pryor never did say any of that. But the court first addressed Idaho Criminal Rule 14 before analyzing whether Chad Daybell has shown that unfair prejudice would invariably result from a denial of his quest to sever his trial from Lori's trial, okay? So the judge lists the Idaho Criminal Rule 14. It says Idaho Criminal Rule 14 provides that a court, in its discretion, Judge Boyce has discretion, may grant relief from prejudicial joinder if a moving party successfully establishes that prejudice will result from a joint trial. And here is Rule 14. And bear with me, you'll learn something. I've learned something myself. Rule 14 says, if it appears that a defendant or the state is prejudiced by a joinder of offenses or of defendants in a complaint, indictment, or information, the court may order the state to elect between counts, grant separate trials of the counts, grant a severance of the defendants, or provide whatever other relief justice requires. In ruling on a motion by a defendant for severance, the court may order the attorney for the state to deliver to the court for inspection in camera any statements or confessions made by the defendants that the state intends to introduce into evidence at the trial. Now here the court notes that Daybell has now twice petitioned this court for an order requiring the state to deliver to the court all statements of the defendants it intends to introduce in trial. In doing so, Daybell has again put the proverbial cart before the legal horse. Twice now, in open court, the state has asserted it has delivered to Daybell every statement of the defendants in its possession. The court is satisfied that the state has complied with its duty to disclose to the defense the statements that might be introduced at trial. There has been no motion to compel relating to an accusation that the state has failed to provide any such discovery to the defense. And you know what that means? That means if any of us, when we go and watch or hear this trial, of course, we're not going to get to watch it unless something changes on that. But in other words, when we hear what goes on in this trial, we're not going to hear any recordings of anyone in an interview confessing. There's not going to be one from Alex Cox anywhere. There's not going to be one from Lori or Chad. The state has turned over all statements that they want to use in this trial. And so the rule expressly provides that the court may enter an order requiring prosecutors to deliver to the court for inspection in camera any statements or confessions made by the defendants that the state intends to introduce into evidence at the trial. However, it is not incumbent upon the court before trial to parse through all statements disclosed in discovery in an effort to surmise the state or defendant's theories of the case, then determine upon its own investigation. While the defense has made general references to quote-unquote statements, there's been no reference to the content of any such statements, either in briefing or argument, for the court to consider. So let's just stop there for a minute. So Judge Boyce is saying, hey, the state has said that they have turned everything over, and neither one of y'all have said that y'all have heard or know about any statements or confessions at all. In fact, John Pryor, says Judge Boyce, you've not done any motions to compel. In other words, hey, I see this and I want to know what this is all about. So again, there is no evidence that any of that's going on at all. And then they go into, accordingly, the court has again been provided no basis to justify the issuance of an order for in-camera inspection, which is part of the criminal rules, that if there were such statements, if there were such confessions, then that would automatically start that. And Judge Boyce said in here, he said, it's not up to me, Judge Boyce. I'm not going to sit here, take all the discovery, go through it, figure out maybe the state's going to talk about this or that. It's not his job to do it, but he is Again, he says the court is satisfied that the state has complied with its duty to disclose to the defense the statements that may be introduced in trial. Okay, and then, of course, it says to reiterate the court's March 21st of 2022 order, and he's going back when he denied it before. He says, despite the extensive discovery that has taken place, defendant has not identified what statement, if any, should be ordered for in-camera review by this court. Furthermore, during the hearing on this matter, the court specifically inquired of the state as to whether any concerning statements or confessions existed that would necessitate the court's review, including whether a Bruton issue exists. The state represented that such statements or confessions did not exist, and the court has considered that representation from the prosecutor as an officer of the court and concluding that an in-camera review is not necessary and will not be required. In conjunction with the state's representation and in the absence of any identification of potentially harmful statements or confessions, defendant's request for such an order is hereby denied. So Judge Boyce is just echoing what he has said before. Counsel for Chad Daybell has argued that he is unable to articulate the content of any statements at issue because of what? Of an existing protective order limiting dissemination of discovery of this case. The court finds that argument to be unpersuasive. Any such statements can be proffered to the court without running afoul of the protective order. The defense is permitted to submit statements for in-camera review or file a motion under seal as set forth in Idaho Criminal Administrative Rule 32 to avoid such concerns. However, this has not been done. Instead, this court agrees with the rationale employed by the Supreme Court in denying severance in State v. Fox, which is, quote, while we do not believe that Fox's attorney needed to reveal his case strategy in open court, Fox needed to provide something more to the district court to establish prejudice than his bare assertion that joining the charges would confound his defense. Daybell has not met his burden to establish that prejudice, if any, and is unfair to Daybell or otherwise impossible to cure through less drastic measures than severance. Prejudice is damage. Now, the definition of prejudice is damage or detriment to one's legal rights or claims. Okay? That's the legalese. That's what prejudice means. You know, we hear the term, oh, you shouldn't be prejudiced against this or that. Well, this is a little bit different. This is saying something is going to keep him from getting his legal rights and the claims of his legal rights. Now, prejudice in the law dictionary says actions properly joined under Idaho Criminal Rule 8b may be severed under Idaho Criminal Rule 14, which governs relief from prejudicial joiner if it appears that a joint trial would be prejudice. And that's State versus Blake. Now, Daybell argues that a joint trial with Vallow Daybell would materially prejudice his right to a fair trial. Number one, by depriving him of presenting a complete defense. Number two, by creating a conflict between a Fifth Amendment right against self-incrimination and the right to an individualized sentencing determination. Number three, by creating a conflict between the alleged co-conspirators' respective constitutional rights, including the rights under the Confrontation Clause. And number four, by frustrating a consideration of mitigating factors in Daybell's case. And finally, five, by imposing upon due process and the right to withhold penalty phase evidence under the appropriate time. And one more, number six, by creating an inherent risk of gender stereotyping that could taint Daybell's right to an individualized sentence. First, Daybell argues that severance is necessary to afford him the opportunity to present a full and complete defense, by demonstrating that Lori and her brother Alex Cox were responsible for the crimes alleged and that they acted in their own conspiracy that did not involve Mr. Daybell. Now let's stop there. How would Chad Daybell be able to prove that through John Pryor? Okay, let me say it again. A full and complete defense by Chad Daybell, as stated by John Pryor, now listen to me, is that it's going to demonstrate that Lori and Alex were responsible for the crimes alleged and that they acted in their own conspiracy that did not involve Mr. Daybell. Now, how would Chad know that? Say Chad was innocent. We're just doing this for sake of argument. Chad is totally innocent, and this is true. How can he prove that instead of, it would more than likely be like Chad gets arrested, he realized he's been duped, so he's now saying that this was Lori and Alex who had a conspiracy of their own. Well, that's just his summation. That's his reasoning. He has nothing to back that up. And if you turn that around, if he had evidence, okay, now stop. If he had evidence that Lori and Alex did this, okay, and it shows that during the time they were conspiring, what's that say? That means Chad was conspiring with them. So it's ridiculous, really. He can't prove it. He can get arrested, say he was innocent and got in jail, and he said, this was Lori and Alex, and they're the ones that conspired. I didn't do it. Well, prove it, Chad Daybell. Because one of two things is going to happen. Number one, they're going to say, well, that's just you just saying, well, it had to be Lori and Alex, with no evidence to back that up. Or number two, you can trace it on back that Chad knew that Lori and Alex was in a conspiracy. That makes him part of the conspiracy himself, you see? Daybell then argues that he will necessarily need to introduce statements made by Alex Cox due to his unavailability to be called to testify at trial because he has since died. Now, how would Chad do that? How would Chad be able to introduce statements that Alex Cox made? First of all, it would have to be statements in Arizona. It could be things he said in text messages. But again, if Alex texted Lori, say, and said something incriminating, that it made it look like it was just Lori and Alex, how would Chad be able to say that he knew about that? And vice versa. The bottom line is Chad would have to have firsthand knowledge. You can have hearsay in certain instances. Chad could get that in, but then it would show that he's a conspirator. Because if he knew back before all this stuff went down that this was going on, and he was able to prove that, yep, indeed, Lori and Alex was doing this and I wasn't doing it, then he had knowledge of it and he could have stopped it. You see? Daybell supports the argument by raising Idaho Rules of Evidence 801D, 2, and E, which expressly allows the introduction of statements made by co-conspirators otherwise inadmissible to hearsay. Just like I said a few seconds before, there are certain things that most people would look at it and say, that's hearsay, but there are certain things that can be brought in that look like hearsay. The state correctly argues that a statement made by a co-conspirator is admissible against all named co-conspirators if made in furtherance of a common scheme or plan. Precisely for this reason, says Judge Boyce, precisely for the reason that Chad would have to introduce statements of Alex Cox to show that it wasn't Chad, it was Lori and Alex, precisely for this reason, the court finds that because of the pending conspiracy charges, keeping the alleged co-conspirators who have been properly joined for trial together is favored and appropriate without necessarily impinging upon any alleged co-conspirator's right to a fair trial. It stands to reason that for exactly the reason Daybell raises, which is the need to introduce certain statements of alleged co-conspirators to mitigate accusations raised against Chad, a joint trial is favored. So John Pryor is bringing up this shit about Lori and Alex, And this is exactly, I guess he's not thinking it through, just as I said before, for other reasons, though. I didn't realize it until I read this. Judge Boyce says this is exactly why they need to stay together. Because if there are statements that are introduced that are not part of the hearsay rule, that are from Alex or whatever, he's saying this is exactly why. And he says, and he talks about this is exactly the reason Chad raises the need to introduce certain statements of alleged co-conspirators to mitigate accusations against Daybell. A joint trial is favored. Now here it goes. Antagonism. Y'all remember antagonistic defense. Antagonism between defenses, or the desire of one defendant to exculpate himself from inculpating a co-defendant, however, is insufficient. It's insufficient to require severance. In other words, for Chad to try to go against Lori and Lori to go against Chad, which is an antagonistic defense, that's not something that's going to be able to say, oh, there, I got the antagonistic defense. That's the only thing we need to see right there. So we're going to sever this case. It says it right there. It says it's insufficient to require severance, and that's United States versus Sherlock. The state correctly notes that this court has already indicated that the alleged prejudice resulting from the introduction of prior bad acts Daybell raises can be cured through motions in limine or careful instructions given to the jury. So the judge is saying, hey, we've got all these options. So if you're wanting these statements to come in or whatever of Alex or Lori or whatever, we've got other options to do here. And Daybell relies on a case from South Carolina, Holmes versus South Carolina, to support his position. However, the case is distinguishable from the allegations raised in the case. Namely, the state of Idaho has charged Daybell with conspiracy among other crimes, whereas the Holmes case turned on the court, finding that a defendant was prejudiced when he had not been permitted to introduce exculpatory evidence that a third party was reasonable for the crime. In this case, to the contrary of Daybell's assertions, keeping alleged co-conspirators joined for trial may ensure a more fair proceeding by allowing a fuller consideration of the distinct alleged individual acts of each co-conspirator by a jury, who then will determine whether or not the state has met its burden to prove beyond a reasonable doubt each element of each crime alleged against the defendant individually. Next, Daybell argues that a joint trial would create a conflict between a right against self-incrimination and the right to an individualized sentencing. In essence, Daybell speculates that any confession of one of the co-defendants necessarily prejudices the other. However, the court inquired, and counsel for both Daybell and the state asserted that to their knowledge, no such confession exists. Thus, the court finds no prejudice arising from this issue, let alone unfair prejudice, in the absence of any potential for the admission of confession evidence at trial. Daybell next raises the argument that a joint trial runs afoul of Bruton and the protection for a defendant from out-of-court statements of a co-defendant in a joint trial where the co-defendant does not testify. As is typical at this stage of the case, it is unknown if either Daybell or Vallow Daybell will elect to testify at trial. And I'll tell you what, I'm telling you, Lori and Chad, either one, they don't have nothing to lose. At this point, I would be shocked if neither one. I mean, maybe one or the other. Maybe it's dependent. If Lori takes a stand because she ain't got nothing to lose, then say Chad will decide to get on the stand too, because it'll look like Chad's just sitting there and Lori's willing to talk. Or vice versa. Chad could get up there and Lori, not want to get up there. and it just doesn't look right. But they're saying they don't see any of that at this time. The state affirmed to the court that there is no Bruton issue at this time and offered an alternative solution to severance should Bruton become germane to these cases, and that is what? Jury, excuse me. So that's 2 juries. I don't know if that's what they're going to do, but he's bringing it up in this order, so there's a possibility that could happen. While this issue is not right before the court, now let's stop just a second. When I say 2 juries, he's just letting John Pryor and everyone know that, hey, we've not met this. It's not ripe. It's not, we're not at this place. Remember, he says the horse before the cart and all this other stuff. He's saying, hey, we've got options right now. And we haven't been faced with statements or Bruton issues or anything else. So there is no, and because we have all these options, there's no reason to sever it. It says, the court is persuaded that Bruton is not appropriately invoked to justify severing Daybell's trial from Lori's at this juncture because there is simply no evidence that any incriminating extrajudicial statements of a co-defendant will be proffered at trial. Turning to Daybell's argument that a joint trial frustrates his right to present mitigation evidence during a sentencing phase, the court again finds the argument is not ripe at this time. So John Pryor's been, in his motion to sever, he was talking about all these things that could happen, and they're not even there yet. The state argues that Daybell has done nothing more than raise bare assertions that his rights will certainly be jeopardized by a joint trial and has not properly put on evidence to prove this argument before the court. And the court agrees. The state suggests to this court, the possibility of requiring separate or sequential penalty phases for Daybell and Vallow Daybell should a single guilt phase trial jury return guilty verdicts against them. So he's talking about all these options that they do have. While the court must carefully evaluate the risk of prejudice in joint trials, there is no constitutional requirement that there be a guilt phase severance of properly joined defendants and offenses, and that's United States versus Edlin. Relying on that rationale, the court determined that on this issue, Daybell has failed to demonstrate unfair prejudice requiring severance. So even then, even though he gives the option in the guilt phase that they could have, they could sever things in terms of the guilt phase, he's saying, there's your option, but at this point, you ain't even showed me that you could do that would even be a possibility. Daybell also makes several arguments that there are variations of the same theme, that capital cases are scrutinized with a heightened reliability, and therefore a joint trial in a capital case prejudices Daybell individually because the state has sought the death penalty. And that's the one that I was hanging my hat on. I thought this is some serious shit. And, if they're going to do it, and with Lori being incompetent, this was before I found out she was competent, I thought they'll do it. This is it. Y'all make no mistake. John Pryor's not going to file another motion for severance. He's done it. He has struck out. There is no more. No more of this crap going to happen. They're going to schedule, just as Kay Woodcock says, they're going to schedule a hearing to have another hearing about the trial date. It's just not going to happen unless there's something that John Pryor can pull out of his ass. He pulled everything out of his ass with 30 plus pages in his motion to sever on this last one. So the bottom line is it's over for them. They're going to have to sit at the table with Lori. Period. End of sentence. To be clear, both alleged co-conspirators have received notice of the state's intent to seek the death penalty. The court, therefore, cannot find from the record before it that Daybell is disproportionately prejudiced if required to stand trial together with this alleged co-conspirator who faces the same maximal possible punishment as Daybell does. And the question really is are they going to get the maximum possible punishment equally? Because that's exactly what they need. Whether they both need to either get the death penalty together or they need to get life in prison together. One should not get a lesser amount of time in the sentencing at all. They should, if they did this shit, they need to go down for it together. Equal, even, Steven. You think about it. Who deserves leniency? Neither one of these damn assholes. They need to go down. The court will assess the propriety of single or separate juries or severing the cases for any penalty phase when the issue is properly before the court and ripe for consideration. In other words, the judge is saying, well, when we get to the penalty phase, then I'll make a decision on whether we're going to sever the penalty phase. None of this, he's used the word, this is premature, this is not right, you're putting the horse before the cart. John Pryor is doing what he's doing. In summary, the court, fully apprised of the complexities and charges involved in this case, nevertheless is persuaded that the joinder of trials remains appropriate. The charges in the indictment include charges for conspiracy, which necessarily involves the agreement and participation of conspirators. The conspiracy charges result in a distinction that matters. It does matter, says Judge Boyce. And again, conspiracy to commit murder, it's ripe, in KJ's eyes, to be joined together. And you know what? And this is my view. Remember how we said that we thought because Alex was dead, they're going to throw him under the bus, he's going to be the scapegoat and all that? It seems to me, and we'll go into this further later in the week, that Alex, his death actually plays against Lori and Chad. It really does. You'll see what I'm saying when I get with you. I believe I'm going to have it all completed on Wednesday, if not Friday, okay? The court determines here that a joint trial of these cases will promote the administration of fairness for each if tried together, where it is clear that there will be substantial overlap in witnesses and in evidence presented related to both defendants, in particular as it relates to the conspiracy charges. It further serves to avoid unnecessary bringing to trial twice over the same witnesses and same evidence bearing on the same charges raised against alleged co-conspirators. A single trial illuminates concerns that the consecutive presentation of witnesses and evidence would result in disparate outcomes and weighs in favor of preserving the right to a fair trial throughout the entire proceedings, from jury selection through deliberations for each defendant. A single trial also diminishes the risk that witnesses necessary in each individual case become unavailable for one but not for the other named defendant. It also serves to avoid the scandal and inequity of inconsistent verdicts, which is United States versus Alvar. Should separate trials upon the same evidence result in disparate verdicts. Finally, a single trial ensures against an unjustifiable expense, but not duplicating what can instead be accomplished through proper instruction to the jury in navigating through the issues raised in Daybell's severance motion. Thus, under the totality of the circumstances and in balancing the numerous arguments raised by Daybell and the state, the court determines that the defense has failed to meet the burden to show prejudice as required by Idaho Criminal Rule 14, and as further explained in the holding of Thune versus State, the court in its discretion finds that the interest of justice remain best served by a single trial for the crimes charged in the indictment filed against Chad Daybell and Lori Daybell. So, some of y'all read the order yourselves. Some of y'all just heard me say they're going to stay together. And I wanted to put it on the record. I wanted to make sure that y'all got that. I wanted to make sure that it was put on our page, on our Ray Room. And please leave your comments. Tell me what you think about any upcoming scheduled hearings that might happen. When do you think that the trial date will be set. And also, what are your comments about the news of last week with Lori being competent? She can't fake her shit anymore now, can she? And also, this news of this joint trial that's going to take place in Idaho, one of the biggest trials that ever, that just absolutely notorious. We're going to see it. Maybe not in the courtroom, but we're going to hear it reported on. We're going to get the audio on it. If we can get the audio of pretrial, East Idaho News has been giving us the audios of these pretrial motion hearings, then we should get it for the trial as well. So I love you all. I'm trying to get back in the swing of things, as I've been saying for the last couple of weeks. It's been tough, but I'll tell you something right now. We are going to get justice through understanding. We're going to do it together. Whether we understand the legalese, whether we don't, we're going to fight for justice for these family members. We're going to do it together. So I love you all. Keep crushing Jason and the rest of their family in your thoughts and prayers. Continue to support difficult research and keep on looking.